Sure. Yes, Mr. Okay. One nimisha. PW9. 9, 10, 21. Married PW. Marriage fixed with the deceased Suresh Naika. ಅವನ್ನ ಯಾಕೆ ಸಾಯಿಸಿದ್ರು? ರಿಕವರಿ ಏನಿದೆ? PW1 ಹೇಳಿದಾಳ? PW21 ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಡಿಸೀಸ್ ಮದುವೆ ಮ್ಯಾಗ ಫಿಕ್ಸ್ ಆಗುತ್ತೋ ಇವನ A1 ಇನ್ವಾಲ್ವ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಾಳ? ದೆನ್ ನಾವೇನ್ ಮಾಡೋದು? The A4 name material, though motive says A9, 10, 11, there is nothing against A1. ಏನ್ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್. 236 ಬೇಲ್ ಆರ್ಡರ್ ಗ್ರಾಂಟೆಡ್ ಇವು ಕೊಟ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ. ವಾಟರ್ ಪಾಪ ಕೊಡಿ.
ಸಪ್ರೇಟ್ ಆಗಿ
the present application file by the accused number 1, 4, and 5. On 16/3/2022, at the ordinance of Section 3 is put up to position. Mainly on the ground that no appeal against the accused number 1 or 4 and 5, the homicide death of the deceased. And the entire case of the prosecution is based on the circumstantial evidence. The circumstance not connected to the death of the deceased, the accused number 1, 4, 5. Is further contended the finding recorded by the trial court against the accused 1, 4 to 5 not based on any cogent material, and prosecution failed to prove beyond reasonable doubt the involved accused. The appellants have got very good case on merit What happened during financial proceedings? During financial proceedings, accused number 1, 4, 5 are on bail. Thereby sought to allow the application. The state has not filed objections. You have heard the learned counsel for the party list. Sri Karnataka, learned counsel for the accused number 1, 4, 5, reiterating the grounds urging not of appealing as well as the arguments made in the application. IA 1 2021 contended that absolutely there is no material against the accused number 1, 4, 5 to connect with the homicide death of the deceased, as the entire case of the prosecution is based on the circumstantial evidence and there are no eyewitnesses to the incident. And the accused number 1 to 4 are all bail throughout the independence of the proceeding, the independence of the trial, and they are not violated any terms and conditions of the bail granted. We further contended that the common charge was made by learned session judge and against all the accused 1 to 5, 1 to 6. Accused number 2, 3, 6 already granted bail by this court in criminal appeal 1259/2021 on 25/1/2022. And 14/12/2021. Thereby is sought to allow the application. The Patatra Sri Majige, learned counsel for the state, while justifying the impugned judgment of conviction, contended that the mobile phone of accused number 1 seized and exhibit MO2, same was spoken to by the prosecution witnesses. Marti car seized at the instance accused number 1. Exhibit P11 under Mother Exhibit P11. PW 9, 10, 21 reports about motive for the murder against accused number 1. As accused number 1 wanted marry PW 21, the marriage of PW 21 was deceased. Thereby, the accused number 1 hatched a plan and involved homicide death of deceased. Therefore, he sought to reject the application. Having heard the learned counsel for the parties, it is not in dispute that the accused persons convicted under the provisions of section 120B, 143, 147, 148, 201, 302, that is 149 IPC. The holding that they have caused death of the deceased, and it is a specific case of the accused person. So the prosecution, all the prosecutors turned hostile, not support case of the prosecution. It is also not in dispute during penitential trial. The accused number 1 was granted bail, was not violated the terms and conditions. But though the learned counsel for the learned SPP tried to convince the court that the evidence of PW 9, 10, 21, they got motive for the accused number 1 who wanted marry PW 21. Marriage was fixed with the deceased. There are no prima facie material to show that the accused number 1 and other accused who have killed the deceased to avoid the marriage between PW21 and the deceased. Stop. Though A1, the mobile phone of Hatunmal sees the exhibit P8 MO2 and Bharti car not belong to the accused number 1. Stop. The entire case of the prosecution is based on the circumstance, based on circumstantial evidence. There is no material to link the accused number 1, 4, 5 from the beginning till the end to prove the homicide death of the deceased and involvement of the accused 1, 4, and 5. It is also not in dispute that during the pendency of the trial, all the accused number 1, 4, 5 were released on bail and they have not violated terms and conditions bail granted. So it is also not in dispute that the other accused 2, 3, 6 are also granted bail by this court. And the said order reached finality. So considering the all circumstances, we have to consider the prima facie case is made out by the accused number 1, 4, and 5 to grant bail. First up, in of the above, IA 1/2020. Which ago? IA 1 actually. IA 1/22 for the under provisions of section 389(1) for suspension and release on bail is thereby allowed. The accused 1, 4, and 5 are entitled to release on bail subject to following conditions. 1 lakh is some. Second, they should not leave the court without. What is the fine amount imposed? What is the fine amount imposed? Accused number 1, 4, and 5 shall execute a personal bond of rupees 1 lakh each with 2 sureties like sum of the satisfaction trial court. And accused number 1, 4, 5 shall deposit the fine amount, if any, imposed by trial court within 1 month. And 1 month from the date of their release from jail. And they should not leave the judicial court without prior permission from the trial court. Yes, sir. Go one by one. No complaint against accused for 2 days by the family members of the deceased. Injured, discharged from the hospital. She was residing in the matrimonial home of the husband. Exhibit 17, the declaration not corroborated any other independent evidence. Motive independence are and same is motivated one. No eyewitness to the incident. PW 1 to 5. Neighbors who doused the fire not support case of prosecution. Now stated the parents are accused 1 to 3 on the date of the incident. Accused number 1, husband shifted the injured to the hospital as was deposed by PW1. Dr. PW10 stated that the injuries has not injured had not stated anything against the accused. A1 deceased residing separately, not along with others A2 and 3. A2, 3 was instigated A1 to marry another woman. The deceased had no children. These are the main points. I was on the lady. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರ್ಬೇಕಂತ ತೋರಿಸಿ ಜನರಲ್ಲ ಬೇಡ ರೀ ಕಂಪ್ಲೇಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಅಕ್ಯೂಸ್ 2 days ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಎಲ್ಲಿ ಹೆಂಗೆ ತೋರಿಸೋದು. Sufficient time for the prosecution is the service of executive magistrate. Not necessary. Executive magistrate ಮಾಡಬೇಕು ಅಂತಿಲ್ಲ. ಯಾರು ಬೇಕಾದ್ರೂ ಅಕ್ಕ ಮಾಡ್ಬೋದು. Only things you should be sound state of mind ಅಷ್ಟೇ. Section 1 is concerned. Section 170. Yes, sir. ಯಾರಿಗೆ? ಹಾ ಬೆಟ್ ಬರುತ್ತಾ ಮೋಸ್ಟ್ ಸಿಮೆಂಟ್ ಇಲ್ಲ ಸಿಮೆಂಟ್ ಹಾಕಿದ್ದು ಅಕ್ಕ ಮಾವು ಫೈರ್ ಮಾಡಿದ ಮುಗಿದೋಯ್ತು ಅಂತ ಹೇಳ್ತಾನೆ. ಆಗ ನನ್ನ ಗಂಡ ಇವಳನ್ನು ಸಾಯಿಸಿ ಅಂತ ಹೇಳಿ ಮನೆಯಿಂದ ಬೆಟ್ ಇಲ್ಲ ಬೆಟ್ 1 year ಸಾವಾಯ್ತು ಅಂತ. No charge for abatement. Allegation ಇಲ್ರಿ. ಅದು ಈಗ ನಾವು ಜಡ್ಜ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. ನೀವು ಒಂದು ಅರ್ಜಿ ಹಾಕ್ಬಿಟ್ಟು ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಆಲ್ಟ್ರೇಷನ್ ಆಫ್ ಚಾರ್ಜ್ಗೆ ಕೇಳಬೇಕಾದ್ರೆ ಇದ್ದಾಗ ಮತ್ತೆ ಈಗ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಅದನ್ನ ಹೇಳಿದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? Is the person who lit the fire? Number 2 is the person lit the fire. ಅವನೇ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ ಆದ್ರೂ ಅಷ್ಟು ಭಗವಂತ ಬುದ್ಧಿ ಕೊಟ್ಟರೆ ಬುದ್ಧಿ ಬಿಟ್ಟಿಲ್ಲ. ಯಾರು ಹ್ಯಾಂಡಿಕ್ಯಾಪ್? ಏನ್ ಬಿಚ್ಚಿದಿ? ಎಲ್ಲಿ ರಾಜ ಮಾಡಿದ್ರಿ ನೀವು? ತೋರಿಸಿ ರಾಜ ವಿಟ್ನೆಸ್ಗಳಿಗೆ. ಹಾ ಯಾರು ಇಲ್ಲ. Yes. Yes, Mr. Majige. ಇವಾಗ there is no dispute between accused number 1 and deceased. They are husband and wife. They are residing separately along with the mother. Mother, ಅತ್ತೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವಳು. ಅಲ್ಲ ಅವ್ರಿಬ್ರೇ ಇದ್ದಾರೆ. ಇವನು ಜಗಳ ಮಾಡ್ಕೊಂಡು ಹೊಡೆದ್ಬಿಟ್ಟು ಸಾಯಿಸ್ರಿ ಮುಣ್ಣ ಅಂತ ಹೊಟ್ಟೋಗ್ಬಿಟ್ಟ. According to the Dain declaration, A2, brother of the accused number 1, A3, wife of the accused number 2, no fuel kerosene. But A2 lit the fire. The incident on 22/8/2010. Well, she was discharged from the hospital. A declaration made on 24/8/2010, 2 days later. Case registered 2 days later. Why? There is a possibility tutoring or implication. Amale, she was discharged from the hospital on 19/9/2010. She went to the maternal home. If really she was tried to burn, kill, she should have said, no, ನಾನು ಹೋಗಲ್ಲ ಮನೆಗೆ, ನಾನು ಸಾಯಿಸ್ಬಿಡ್ತಾರೆ ಆಮೇಲೆ ಹೋದ್ರೆ. ಅವ್ರ ಅಪ್ಪ ಅಮ್ಮ ಮನೆಗೆ ಹೋಗ್ಬೋದಾಗಿತ್ತು. If there was a threat from the husband or the brother-in-law, she should not have accepted, no, ನಾನು ಹೋಗಲ್ಲ ಅಂತ ಇದ್ಲು. Thus some doubt. Tutoring. ಅಲ್ಲೋಗಿ ಅಲ್ಸತ್ತಾಳೆ, ಸತ್ತಿರೋದು ಸೆಪ್ಟಿಮಿಷಿಯಾ. ಕರೆಕ್ಟ್, ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡಿಲ್ಲ, ಸತ್ತೋಗಿದ್ದಾಳೆ. ಇವಾಗ ಅವಳು A3 ಅಬ್ಸ್ಕಾಂಡಿಂಗ್ ಸಿಕ್ಕೇ ಇಲ್ಲ, ಸ್ಪಿಟ್ ಅಪ್ ಚಾರ್ಜ್ ಶೀಟು. A1 ಏನು ಇಲ್ಲ ಅವನ ಮೇಲೆ. A2 ಅವನು ಲಿಡ್ ದಿ ಫೈರ್ ಹತ್ತಿ, ಯಾರು ಬಂದು ಹೇಳಲ್ಲ, ನೋ ವಿಟ್ನೆಸಸ್. ಅವನು ಫಿಸಿಕಲಿ ಚಾಲೆಂಜ್ ಪರ್ಸನ್ A2. ಎಂತ ಮಾಡ್ಬೇಕು? No other evidence. Interested. Whether you have examined mother-in-law, she is the prime witness to the case of prosecution. ಅವ್ರಿಗೆಲ್ಲ ಗೊತ್ತಿದೆ, ಅವ್ರು ಕೇಳ್ಬೇಕಾಯ್ತು. The parents examined. They have said anything about accused number 1 or accused number 2? Except this statement of Dain declaration. ನಿಜವಾಗ್ಲೂ ಮಾಡಿದ್ರೆ ಅವ್ರ ಅಪ್ಪ ಅಮ್ಮ ಹುಡುಗಿನ ಆಸ್ಪತ್ರೆಯಿಂದ ಅವ್ರು ಕಳಿಸ್ತಾ ಇಲ್ಲ, ಮನೆಗೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಡೋರು. ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಅವಳದೆಲ್ಲ ಚೆನ್ನಾಗಿದೆ, ಕಂಫರ್ಟಬಲ್ ದೇರ್. 313 ತೆಗೀರಿ. ಕರೆಕ್ಟ್. ಇವಾಗ ಮಿಸ್ಟರ್ ಬಜ್ಗೆ, ಅವ್ರ ಮಕ್ಕಳು, ಗಂಡು ಮಕ್ಕಳು ಸೊಸೆಗೆ ವಿರುದ್ಧ ಇದ್ರೆ ಯಾವ ಅಮ್ಮನು ಮಕ್ಕಳ ವಿರುದ್ಧ ಸಪೋರ್ಟ್ ಮಾಡೋ ಸೊಸೆಗೆ? ಇದರಲ್ಲಿ ಇವನು ಪಿ ಎಚ್ ಅವನು ಹಾಳಾಗಲ್ಲ, ಬಿಟ್ಬಿಡ್ತೀವಿ ಸಾಕು. 11 ವರ್ಷ ಒಳಗಡೆ ಎಂತ ಮಾಡ್ಬೇಕು? $498 acquitted, only 302. ಗಂಡನ ಮೇಲೆ ಇಲ್ಲ, ಅವಳು ಓದ್ಲು, ಅದೇನಾಯ್ತು ಗೊತ್ತಿಲ್ಲ, ಅವಳ ಮೇಲೆ ಏನು ಕಾಣ್ತಾ ಇಲ್ಲ. A2 is physical handicapped ಭಾವ. ಅವನೇನ್ ಮಾಡ್ತಾನ್ರಿ? ನಥಿಂಗ್, ಕ್ಲೋಸ್. ಬಾಮ Muhammad, this is not where you argue. ಸ್ಟೆಪ್ ಬೈ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. ನೀವು ಜನರಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಕುತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಹೆಂಗ್ ಮಾಡೋದು ನಾವು? The accused number 1 who is the husband of the deceased Sarita. Accused number 2, brother-in-law of the deceased and brother of the accused number 1, who is a physical handicap. Physical handicap. Who is a physical handicap. Number 3 was outstanding. The physically challenged person and cannot walk much. Accused number 3, wife of the accused number 2 was absconding. Split of charge sheet filed. 2010 ಇವತ್ತಿಗೂ ಅವರ ಅಮ್ಮನ ಹುಡುಕಿಲ್ಲ. The police not able to find out. ಏನು ಬರಿಬೇಕಲ್ಲ. ಅಮ್ಮ A3, wife was absconding, split of charge sheet filed. The accused number 1 and 2 filed the present criminal appeal against the impugned judgment of conviction. Order of sentence dated 20th September 2017, made in SC 123/2011, convicting the accused number 1 and 2 for the offence punishable with foul subject 302 IPC. It is the case of the prosecution that based on the statement of the victim, Srimati Savita, dated 24/8/2010, the judicial police treated the dying declaration, treated the victim's statement as complaint and registered in claim number 241/2010 under the provisions of section 498A, 307, revision 34 IPC on 24/8/2010 at about 15:30 hours. First up, it is the case of the prosecution that the accused number 1 married the deceased Savita as he was harassing by telling her that she is a barren, as she was having no children. He was harassing both physically, mentally. But upon 28/2/2010, at about 8 p.m., when the accused 1 to 3 was abused the deceased for not having any children. Then the accused reacted, the deceased reacted, why you are blaming? Thereby the husband, accused number 1, has pulled her the air that she is retaliating. And thereafter, the accused number 2 and 3 abuse her filthy language. And accused number 1 blaming lady has to be killed and went away. Thereafter, accused number 1 and 3, accused number 2 and 3 poured kerosene on the deceased, and accused number 2 lit the fire. Thereafter, PW1 and others on screaming by the 15 extinguished the fire, and mother-in-law of the deceased, that is the mother of the accused number 1, or the instance of the mother-in-law of the deceased, or the mother of the accused 1, who was sent to Ramnagar Hospital for treatment. Thereafter, on reference, was sent to Victoria Hospital. And our statement was recorded on 24/8/2010. Was discharged from the hospital on 19/9/2010. Subsequently, he died on 6/10/2010. Thereafter, our father, complaint ಕೊಡ್ತಾರೆ. PW2 Narasimhappa has lodged one more complaint, Exhibit P2. Based on the opposite complaint, the last complaint on 7/10/2010 at about 9 p.m. Thereby, the provisions of section 307 was thereby 307 was converted into 302 IPC by the judicial police on the complaint by PW2. So after investigation, the judicial police filed charge sheet against the accused under the provisions of section 498A, 302, reduced to 34 IPC. So next paragraph. After the matter committed to the learned session judge, the learned session judge secured the presence of the accused persons and framed the common charge against the accused 1 to 3 under the provisions of section 498A, 302, reduced to 34 IPC. Read out to the accused in the language known to them, who pleaded not guilty, time to try. In order to prove the case of the prosecution examined in all PW 1 to 15 and material documents exhibit P1 to P12 and material objects MO 1 and 2. After completion of the evidence of prosecution witnesses, the statement of the accused as contemplated under the provisions of section 313 CRPC was recorded. The accused persons denied all incriminating circumstances adduced by the prosecution witnesses. Not adduced any defense evidence. Next paragraph. Based on the posted material record, the learned session judge framed 2 points for consideration. Considering both oral and document evidence on record, the learned session judge answered the point number 1 in negative and point number 2 the affirmative, holding that the prosecution failed to prove beyond reasonable doubt accused number 1 for living with the Sarita gave a physical mental harassment that she is a barren, and thereby committed offense which was to 498 reduced to 34 IPC. Further held that the prosecution proved beyond reasonable doubt on 28/2/2010 about 8 p.m. night the accused person's common intention when Savita was in the house picked up quarrel with her set fire by pouring kerosene, causing burn injuries, and she died on 6/10/2010. Thereby committed an offense which was 302 with for IPC. So accordingly, the learned session judge by the impugned the judgment order of acquittal, by the impugned judgment order of sentence dated 20th September 2017, convicted accused number 1 and 2 under the for the offence punishable in provisions of section 302 34 IPC for imprisonment of life, the fine of rupees 10,000 each, and accused number 1 to 3 are acquitted for the offence punishable under the provisions of section 498A. The state government has not filed an appeal against the acquittal for the offence punishable provisions of 498A, reduction 34 IPC. Hence, the present appeal is filed. We have heard the learned counsel for the parties to this. Sri Muhammad Pasha C, learned counsel for the accused 1 and 2, mainly contended that the impugned judgment of conviction convicting the accused 1 and 2 for the offence of violence of 302 IPC with fine of 10,000 is erroneous, contrary material record cannot be sustained and liable to set aside. We would further contend it that though the incident occurred on 22/8/2010 in the house of the accused number 1, the members of the deceased family have not lodged any complaint against accused more than 2 days, and there was a delay in filing the complaint. Thereby, it is a patent to the case of the prosecution. So we would further contend it that the declaration, the declaration, the statement of the deceased was recorded only on 24/10/2010 as per Exhibit P17, and she discharged on 19/9/2010, and thereafter she was residing with the accused number 1 family along with his mother, the mother-in-law of the deceased. And she died on 10/10/2010. Thereby, the prosecution has not proved case beyond reasonable doubt. So, to further contend, there are no eyewitness to the incident. PW1 and 5 with the neighbors who doused the fire not support case of the prosecution, nor the presence of accused number 1 to 3 on the date of the incidents were disclosed. Accused number 1 being the husband of the deceased shifted the injured to the hospital. First hospital, Ramnagar hospital, thereafter shifted to Victoria hospital. Two by PW1. So we would further contend that Dr. PW10 Dr. Kodra Delhi stated that the injured not repose anything of the accused persons. So we would further contend accused number 1 and 3 residing separately, not along with accused number 2 and 3. There is no material to instigate the accused number 1 to marry another woman, as the deceased had no children. So, we would further contend that Exhibit P8 MLC register depicts history of accident of burns and she was shifted by her husband from the hospital to the Victoria Hospital. But admittedly, mother-in-law was material witness, not examined by the prosecution. Would the deceased to the hospital, and after discharge, deceased went to her maternal home, residing along with the accused number 1 and mother-in-law. Matter was not under consideration, thereby erroneously convicted the accused in the cause of 602 IPC. Contended against the impugned judgment of order of acquittal passed by Telecast, acquitting the accused number 1, 2, 3 under the province of section 498 yes ARPC, has reached finality.
To be under the provisions of section 498 ACRPC has reached finality.
The state has not filed an appeal. Thereby, he sought to allow the appeal. So for contra, the Majge Leonard Additional SPP, while justifying the impugned judgment of conviction or of sentence, contended that though there was delay in the record statement of the team on 24/8/2010, though incident occurred on 22/8/2010, the fact remains that they were concentrating to save the life of the deceased rather than imposing, rather than lodging complaint. Stop. You ended the statement of the deceased Sarita, who subsequently called a rain declaration, clearly depicts that accused number 1 and deceased Sarita were living together, and the accused number 2 and 3 residing separately. On the date of the incident, when the accused 1 abused the deceased for not having any children as his bearer, the same was supported by the PW2 accused number 1 and 3, who also blamed. Thereafter, after quarrel sometime, the accused 1 husband went away. Thereafter, PW2 and 3 poured kerosene, and accused number 2 set the lit the fire. Thereby, the prosecution proved beyond reasonable doubt the involvement of the accused. It would further contend that though the accused was acquitted under the provisions of section 498 and 34 IPC, the fact remains that the accused person given life imprisonment. Thereby, the state has not filed any appeal. Therefore, he sought to allow the writ petition. Sought to dismiss the criminal. Next. Court, we are given our anxious consideration. The argument advanced by the learned counsel for the parties. Any of the opposite rival contentions urged by the learned counsel for the point that would arise for consideration the present appeal is whether the accused number 1, whether the trial court is justified convicting the accused number 1 and 2 for the offense punishable cause of 302 IPC, and whether the accused 1 and 2 made out a case to interfere with the same, the peculiar facts of the present case. We are given our anxious consideration. The argument advanced by Dhanapati for record, including original records carefully. Next para. The court, being the appellate court, in order to reappropriate the entire material of both one document and record relevant to consider the evidence of prosecuting witnesses and the document relied upon. Roman Varna. Roman Varna. Rajappa, PW1, who deposed that accused number 1 and 2 from his mother place. We have seen this is Channamma. Channamma, Sarita Alva. We have seen the wife of Krishnappa Tare. This is Sarita, wife of accused number 1. They had no issues out of the marriage. On the date of the incident, he was present in his parent house. Did not know how the deceased died, and I have not seen set the fire to her by pouring kerosene, and they have not gone to hospital. Thereby, I was treated hostile. PW2 Narsimappa, who is the father of the deceased, other than the father of the deceased, supposed that Savita was given to marriage to Evan Swami and they were residing as husband and wife. A2 and mother in Tummenahalli. At the time of wedding, he gave Savita gold rings, jumki, ring cloths, and he gave one gold ring and rupees rupees 10,000 to the accused number 1 and performed the wedding at his cost of Kengal. And they were happy during about 6 months. Later, his daughter was told him that the deceased accused number 1 to further dowry of rupees 10,000 from the family for family problems, for which he refused. He visited his daughter in Victoria Hospital. And his daughter told him that the father-in-law had spilled kerosene. Brother-in-law spilled kerosene and set the fire. At the time, nobody was present in the house. He intimated that she had back to the police as well as the medical officer. He was an inpatient in the hospital 1 month later. Hospital wanted to her change place. Yes, we brought to her village. She died after 3 days. Exhibit P2 is the complaint. Examination that the deceased brought back from the hospital to Timbenahalli. The accused persons as well as Channamma did not get proper treatment. Hence, she died on 6/10/2010. That I lodged a complaint exhibit P2. Thereby support case or past question. PW3 Vinod Murthy, younger brother of Illa, ಇವನ್ ಮಗ, PW2 ಮಗ. PW2 is the brother of the deceased who deposed that prior to the 2 years prior to the incident, the marriage of the accused and the deceased was performed in Bengal at the cost of her father. And she was residing at maternal home along with her husband, A2, and A2, wife of A2, and mother-in-law. Later, he came to know that her sister had no issues, hence they were torturing. About details of torturing, he don't know anything about torturing. ಇನ್ನ ಕಾಗದ ಮಾಡಲ್ಲ ರೀ. Further admitted in the cross-examination that it is true that in Tumbenahalli only his sister and the mother-in-law were present. Later we did not secure any treatment. He further denied that narcotics that Dev2 was residing with his family member separately. He informed the deceased informed about the incident. The witness volunteered that if we look after treatment expenses, if the husband or others visited her, it's up to the own ತಗೊಂಡು PW4, Timothy Meenakshama, mother of the deceased, who deposed about the marriage between the accused and the accused deceased. The father deposed that about 2.5 years back, her daughter died and she was in maternal home. He told during the first year of marriage that they were taking good care. Later she stated that they will ill-treating us. He told us that they were harassing for demanding her father, dowry, and also having no issues. Therefore, she instructed his daughter to adjust the life in the maternal home. After knowing the incident, they came to the hospital, and his daughter was fully burnt. On inquiry from the daughter, she told both the accused persons before the court, Chennamma said the fire, even though she opposed, was in hospital around 1 month. Later, doctor advised her to change the place. Support a case or prosecution. He would further contended that the complaint took to the place of the incident when his daughter was in hospital, and they are conducted Panchanama to exhibit to which affects LTM. The exhibit P3 is the LTM. Just identified MO1 and 2. Nothing has been elicited in charge of disbelief is what case said in the exam in chief. PW5, Tamaya, who deposed, is from the same village where the accused is residing. You know the both of them. That while fueling kerosene, the stove fire broke out about 4 years ago, about 7 p.m. Other time, I was inside the house. Went to the spot. A general public running there. I saw this is Savita burning, but at the time she was shifted to hospital by her mother-in-law. Accused person was not present in the house. He further admitted not attempt to extinguish the fire. They took her to hospital Bengaluru. She was brought from hospital. She told after coming from the hospital, the stove burst happened and fire was caught. What is about case of proceeding? PW 6, PW 6 and 7. Punch witness to the exhibit P5. Inquest Panchanama have been treated as partly hostile. PW 8. Stated to the eyewitness, but does not support case of the PW 9. Dr. Raju, MMS, who deposed that on 22/8/2010 at about 9 p.m. Srimati Savita, 25 years, brought through 108 ambulance, accompanied by her husband, Swami, accused number 1, with history of accidental burns. Immediately intimated the complaint to the police through a memo and referred the patient to the hospital. After found first at same as per exhibit P7. Doctor was not cross-examined. Period of 9 not examined. Not examined. PW 10, Dr. Siddheshwar, who deposed that he was working in casualty medical officer hospital on 23/8/2010. The district hospital referred victim Saita with history of burn injuries to the Uttar hospital for eye treatment. About 11:45 a.m., he was brought to the hospital when then he recorded the details of the MLC register, then referred the injured to specialist burn ward. In the MLC, the victim Savita gave a history in the nature of accidental burns. ML register victim Savita gave a history in the nature of accidental burns. Went to lamp, accidentally got fired, and burn brought to hospital by her husband, Swami. The MLC register to by the medical officer is not with P8. PW can also not cross-examine. Except the word cross-examination that prove that the bird injuries could happen in case of accident of stove burst. That is not the case of the prosecution. Stove burst with Ilwala. PW Soumya. Of the disease. Who reports that she know all the accused persons before the court. Death. After the marriage, deceased was residing with her husband in matrimonial. Both accused persons were harassing her sister by stating that she had a barren, no children. Accused number 2 used to ask her to come. When sister was sleeping, both the accused persons put kerosene through window and set the fire. Thereby, there the deceased intimated her poor sister that her husband had pure kerosene and set the fire when she was sleeping. Improvement is support case of prosecution. PW 11 PSI because that had been working as PSI on from 40 to the 9 to 36 to 11. Conduct partial investigation. Under investigation to Chief Second Inspector of Police. Support case of prosecution. PW 13 HN Dharmendra. US with the by Madhugiri. Because that 2018 was working as Inspector of Police. He conducted investigation taking charge from 24 from 2010 to 2010. Continued investigation. Inspector is fought. Deputed the police personnel to secure the presence of the accused. And after completion, investigation file charge sheet. PW 14, Dr. Srimati Usha reports that he is the Ramnagar Jilla Hospital. Senior specialist on 7/10 to 10. He received information from Ramnagar rural police station. The crime number 2/1 2010 and KK 302 graduate 1634 APC. Conduct at post-mortem on request made by the judicial police from 1:30 to 2:30. Ramnagara Maturi Hospital. For case of prosecution. Exhibit B12 is the PM report. Support case of prosecution. between DB Natesh, sorry, Assistant Commissioner. Asunda, looking from 5/9/2009 to 12/9/2020. He has requested, he has conducted inquest Pachrama on the request made by the police dated 7/10/2010. And submitted the press report. Submitted Shivapati. That PM postmortem report has been based on the aforesaid material, Karnataka Session Judge proceeded to convict the accused on in view of the evidence of prosecution, in view of the case of the prosecution, it is undisputed fact that the unborn incident occurred on 22/10/2010, and the dying declaration, the statement of the accused was recorded on 24/8/2010, after 2 days from the date of the incident. The declaration was made by the deceased on 24/8 to the statement of the Jude was recorded on 24/8/2010. At about 8 p.m. night, narrating the incident occurred. Based on the same statement, the claim number 241/2010 was registered initially at the inception 498A, 307 edition 34 IP. Admittedly, she discharged from the hospital on 19/9/2010 and started residing with her husband and mother-in-law in the matrimonial house. So, if the case of the prosecution were to be true in terms of the dying declaration, there would not be a possibility person who's sustained injuries, burn injuries, will accept to go to the matrimonial home again. Stop. In case of the evidence of the prosecution witnesses, including PW2 father, PW2 father, PW3 brother, the deceased, that and 11 elder sister, that due to the unfortunate incident, they don't want to send the This is again the maternal home, nor this is, I express unhappiness to residing in the maternal home. So clear that the deceased having suffered burn injuries and having made a statement on 24/8/2010 and after discharge on 19/9/2010, he was residing in the maternal home along with the accused number 1 and the mother-in-law till 16/10/2010. 10/2010. About 15 days, more than 15 days. Stop. Next paragraph. In the present case, as can be seen from the alleged statement of the team, so after death, subsequently it was converted. Under the provisions of 1002 on the complaint made by PW2 as per exhibit P2, comma, nowhere in the declaration or complaint allegation against the accused number 1 scolded the wife and went away. It is a specific case that the accused number 2 and 3 scolded for not having the children as barren lady and cured corruption. Accused number 2 certified, but there are no eyewitnesses to the incident on unfortunate day. Very strangely, exhibit P8, MLC registrar issued by PW9 clearly depicts that history was accident burns, and PW9 whose deposed before the court that the victim, the deceased was shifted by her husband to the Ramanagara Government Hospital. Thereafter, she was shifted to Victoria Hospital. Fortunately, the prosecution not cross-examined PW9 doctor. So, it is also not that after the incident occurred and occurred on 2/8/2010, and after the statement declaration made on 24/8/2010, he was discharged from the hospital on 19/9/2010. He was all along residing with the maternal home of the accused number 1 and his mother, the mother-in-law of the deceased. Admittedly, the mother-in-law of the deceased, who is the material witness in the case of the prosecution, not been examined. Thereby, the prosecution, the case of prosecution is a fatal. Thereby, the fatal case of prosecution. So, the prosecution not explained delay in registering the case. Delay of 2 days registering case. Delay 48 hours. 48 hours of delay in registering case. As the incident occurred on 22/8/2010, and the declaration was made before the hospital on 24, it was not about 8 p.m. And the scope of the exhibit P617, the constable PC, the HC P73 not examined. It is also not in dispute that the learned session judge considering the entire material record, though the common charge was made against the accused 1 to 3 under the powers of section 498, 3 or 2 reduced 34 IPS. The learned session judge proceeded to acquit the accused persons under the powers of section 498A, reduced 34 IPS. And the state government has not, the state has not filed an appeal against the said acquittal. To stop. It is also not in dispute. There are no eyewitness incidents as already said Supra. PW1 and 5 with the neighbors who douse the fire not support case of the prosecution, nor stated the presence of the accused number 1 to 3 on the date of the incident. It is also not in dispute. It is also not in dispute that accused number 1, husband shifted the injured to the Ramnagara Government Hospital. Thereafter, to the Victoria Hospital, as deposed by PW1, and Dr. PW10 would depose that the injured has not stated anything about the accused. Who specifically stated on oath depose that on 28 2010 he was working in casualty as casualty medical officer, Victoria Hospital, Bengaluru. The district hospital referred the victim Savita with history of burn injuries to the hospital, Victoria Hospital, for area treatment. At about 11:45 p.m., 11:40 a.m., she was brought to Victoria Hospital. Then they record details in the ML's register, then referred the injured to the specialist burn ward. Put up. In the ML's register, the victim Savita gave a history in the nature of accidental burns. While pouring kerosene to the lamp, accidentally she got fire and sustained burn injuries. She brought to the hospital by her husband Swami. The extract is placed before the court. ML's extract is placed before the court, and the original ML's register also brought by the medical officer, marked as Exhibit P8. Put up. The cross-examination, he admitted that it is true that burn injuries could happen in the case of an incident of stove burst. The Mr. Majge, Victor Hospital doctor fixed to put an exam. He has not whispered anything about the statement of the victim recorded on 24/2/2010. So, plain declaration. Now, the doctor who gave a fitness certificate on Exhibit P17, endorsement, who gave endorsement on Exhibit P17, not examined. Put up. Thereby, in view of Exhibit P8, ML's register, evidence of PW9, evidence of PW10, doctors, medical doctors, And after the discharge, she went to the matrimonial home on 19/9/2010, and she was residing along with the husband and mother-in-law till 6/10/2010, where she died due to septicemia, as stated by the doctor PW12 and issued exhibit PW14. Doctor issued PM report exhibit P12 that the cause of death is due to septicemia as a result of burns. First of, in of the above, the statement of victim, exhibit 70, subsequently dying declaration is suspicious and doubtful. First of, none of the witnesses whispered against the none of the it is not the case of prosecution that husband proved kerosene. As per the statement of the victim, the husband scolded and went away. It is the accused number 2 and 3 who poured kerosene, and accused number 2 set the fire. There are no eyewitnesses except the statement of the victim. There is no other corroboration. In view of exhibit P8, ML's register issued by the doctor during course of the upsell business clearly depicts history of accident burns and was shifted by accused number 1 husband to the Victoria Hospital. And non-cross-examined PW9 who issued MLC clearly depicts that the case of prosecution is suspicious, and the learned session judge has not considered the said material aspect, thereby proceeded erroneously to convict the accused 1 and 2 based on the exhibit P17 alone, without there being any cooperation. The same cannot be sustained for the absence of any other corroboration. Admittedly, no material is placed against the accused number 1, husband of the deceased, except the statement of deceased against accused number 2 and 3. There is no other material. The said statement cannot be believed in view of exhibit P8, MLC register, and evidence of doctor who issued MLC register on examination of PW, examination of the victim, PW9 and PW10 doctors. Admittedly, the doctor who issued fitness certificate, endorsement, fitness endorsement on exhibit submit not examined. Thereby, the case of the prosecution is doubtful. And out of the exhibit 17 is not examined. These are the interior circumstances that the case of the prosecution is doubtful. Stop. Golden thread Kodi. It is well settled that a dying declaration could be the sole basis of conviction even without corroboration, if it inspires the confidence of the court. The court should satisfy that the declarant was a fit state of mind at the time of making statement, that it was voluntary statement, which was not result of tutoring or prompting or imagination. Where the dying declaration is suspicious, suffering from any infirmity, such as want of fit state of mind of declaration like nature, it should not be acted upon without corroborative evidence. When eyewitness affirmed that disease was not fit unconscious state of, the medical opinion cannot prevail. Admittedly, in the present case, though the accident incident occurred on 22/8/2010, the declaration, the statement recorded, deceased statement was recorded, victim statement recorded on 24/8/2010, more than 48 hours, delay not explained. And apart from that, the person who gave the fitness certificate on the exhibit P17 not examined. Stop. In view of the inconsistency of the evidence, material evidence, exhibit P8, the oral evidence of the doctor PW9, PW10, and the material witness mother not examined, the trial court was not justified convicting the accused only on the sole basis of suspicious dying declaration, suspicious statement of the victim, exhibit P17. Subsequently, it is called as dying declaration, and it is unsafe to rely upon and convict the accused person. Stop. Moreover, PW2, the brother-in-law, accused number 2, brother-in-law of the accused, who is physically handicapped, brother-in-law the deceased, brother accused number 1, was physically challenged person and cannot walk much. Stop. The learned session judge proceeded to convict the accused 1 and 2 mainly on the basis of exhibit P17, ignoring the other circumstances, other material documents about the declaration, about the statement, record statement with the accused. This is so subsequent dying declaration is suspicious. Next paragraph. It is well settled that there is no embargo on the appellate court reviving the evidence upon which an order of conviction based. The golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible on the evidence adduced, the case, one pointing to the guilt of the accused, under the other to his innocence, the view which is favorable to the accused should be adopted. The paramount consideration of the court is to ensure miscarriage of justice is prevented. A miscarriage of justice which may arise from the acquittal of guilt is no less than from the conviction of innocence. After careful examination of the charge made against accused persons and the evidence on record, so beyond shadow of reasonable doubt, the shadows are dark enough to eclipse the truth. The learned session judge has ignored number of reasonable doubts which legitimately arose on the evidence led by the prosecution, witnesses, and its conduct in suppressing the vital documents and witnesses which clearly indicate the prosecution has not proved the guilt of the accused persons beyond reasonable doubt. The non-expression time gap between the incident and lodging complaint and non-production of the material documents and non-cross-examination of the doctor clearly prove that it is a case prosecution is doubtful. The said aspect has not at all been considered by the learned session judge while convicting the accused. Next paragraph. For the reasons stated above, the held court, the point raised in the present appeal as to the answer negative holding that held court is not justified in convicting the accused 1 and 2 under the provisions of section 302 IPC for imprisonment of life, and the accused 1 and 2 has made out a case to interfere with the impugned judgment conviction order passed by the held court. Next paragraph. For the reasons stated in of the above, we pass the following order. The criminal appeal 1947 filed by the accused number 1 and criminal appeal 621 filed by accused number 2 are hereby allowed. The impugned judgment of conviction order of sentence passed by the court convicting the accused 1 and 2 for imprisonment of life with a fine of 10,000. Default cost hereby set aside. Accused number 1 and 2 are hereby acquitted for the offence first to thousand subsection 302 IPC. Whether they are in jail or released on bail. The accused number 2 in criminal appeal 628, but the judicial jail authority have directed to release accused number 2 in criminal appeal 628 forthwith if is not required for any other case. The bail bond excluded by the accused number 1 is stand by hereby cancelled. ರೆಡಿ ಆಗಿ ಬರಬೇಕು, ಫ್ಯಾಕ್ಟ್ಸ್ ಇಲ್ದಂಗ ಆಗಲ್ಲ. ಇದೆಲ್ಲ ಹೇಳ್ಬೇಕು, ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ಬೇಕು. ದೀಸ್ ಆರ್ ಸಸ್ಪಿಷಿಯಸ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್. MLC, PW ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮ್ ಮಾಡಿಲ್ಲ. ಅಲಿಗೇಷನ್ಸ್ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ A2 ಫಿಸಿಕಲ್ ಆಕ್ಟಿವ್ ಪರ್ಸನ್ and residing separately. ಅಲ್ಲೊಂದ್ ಕಡೆ ಅಡ್ಮಿಟೆಡ್ಲಿ ಕಡೆ A2 ಮೇಲೆ ಏನಿಲ್ಲ ಅಂತ ಬರ್ತೀನಿ. ಫಿಸಿಕಲ್ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ admittedly A2 and A3 are residing separately and not along with the deceased or accused number 1. None of the witness deposed. None of the witnesses whispered anything about the together, residing together. In the absence of said, possibility implication of the accused number 1 and 2 cannot be ruled out. ಸ್ಟೆಪ್ ಬೈ ಸ್ಟೆಪ್ ಜಡ್ಜ್ ಮೈಂಡ್ ಫ್ರೆಶ್ ಆಗ್ಬೇಕ್ರಿ. ನಾವು ಹುಡುಕಿ ಬರೀಬೇಕು. ಯಾವ ತಕ್ಕ ಮರಿ ಒಂದು ಕ್ವಶನ್ಸ್ ಇಲ್ಲ ರೀ. ನಮ್ಗೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೊಡಿತಾರೆ, ನಾವೇ ಯೋಚನೆ ಮಾಡಿ ಈ ಕಡೆ ಆ ಕಡೆ ಹೊಡೆದು ಒದ್ದಾಡ್ಬೇಕು. ನಾವು ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ಬೇಕು, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ನಾವು ಒದ್ದಾಡ್ಬೇಕು. ನೀವು ಹೇಳೋದಿಲ್ಲ, ಸಿನಾಪ್ಸಿಸ್ ಕೊಡಲ್ಲ, ಒಂದು ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡಲ್ಲ. ಇವಾಗ ಒಳ್ಳೆ ಫೀಸ್ ತಗೋತೀರಾ, ತಗೋಬಾರ್ದು ನೀವು. ಯುವರ್ ಕಾನ್ಸಿಯಸ್ ಪರ್ಮಿಟ್ಸ್ ನೋ ಫೀ ಫಾರ್ ಮೀ ಅಂತ ಹೇಳ್ಬೇಕು. ತಗೊಳ್ಳಿ, ನಿಮಿಷ ಅಲ್ಲಪ್ಪ. ಪಾಷಾ, ನಾವೆಲ್ರಿಗೂ ಅವಕಾಶ ಕೊಡ್ತೀವಿ. ವಿ ಓನ್ ರಿಕ್ವೆಸ್ಟ್ ಮೆಂಬರ್ ಆಫ್ ದ ಬಾರ್, ಪ್ಲೀಸ್ ಅಸಿಸ್ಟ್ ಪ್ರಾಪರ್ಲಿ ವಿತ್ ಸಿನಾಪ್ಸಿಸ್, ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಎಲ್ಲಿ ಸಣ್ಣ ಕ್ಲೂ ಸಿಕ್ಕಿದ್ರು ಇಟ್ಕೋಬೇಕು, ಕ್ಲೂನ ಹೇಳಿಬೇಕು. ಆಲ್ರೆಡಿ ಅವನು 11 years ಇದ್ದಾರೆ ಇನ್ ಸಫರಿಂಗ್ ಜೈಲ್. ಕುಂಟಾ. Yes. Yes. Amma. Synopsis. Synopsis. Podi. Yes. What is this? Not 2. 397 robbery. 302. Oh, 307. 307. Ah. 333. 333. 333. Now, that is immaterial for us. What is the case? Convicted all the sections. Don't start with jail. Already we are immaterial for jail. We want only the case. If we have no regret, if these people are suffering, murdering innocent people merely because they are 10 years jail, it's immaterial. Make out a case, will release. Otherwise, confirm forever till death. You are obstructing the causing grievous hurt to the person, public duty, thereby permanent
Public servant.
public servant. You killed that man. ಅದು ತೋರಿಸ್ಬೇಕು ಆಲೋಚನೆ ಹೆಂಗೆ ಅಂತ ಅಮ್ಮ ಮೇಡಮ್ first we narrate the facts, read the complaint and the witnesses who spoke about sudden provocation. Yes, first narrate the facts. 3 accused persons. 3 accused. What is the relationship between these people? They are friends. Satish, Anthony, Pradeep. They are strangers. No, that is immaterial, ma. First, just narrate. Satish, Anthony, Pradeep, they are friends. Then, how to join to kill that man? Ah. These people. ಇವರೇ ಕಿತ್ಕೊಂಡಾಗಿದ್ದು ಅಂತ these 2 people 100 rupees. Officer, what happened that person who lost 100 rupees? No, see, these 3 people snatched 100 rupees from the passenger. Passenger informed the railway. All right, stranger informed to the police inspector. These people, all right, these people snatched 100 rupees. There you went to inquire. Before inquiry, all right, they will pull like this. They will pull like this. Correct. Immediately, you should have said immediate guilty, not guilty. You can't remove and stop. Why you have kept the knife in your pocket in the railway station? With the knife. Police with the knife, how it comes to you? No, ma, please answer. Now you are coming to court. You come with court with gun or knife? If they stay streets, they should leave with the knife. Rohini, you are Rohini, Sohani, Sohani. We want answer from you, being a officer of the court. The persons who are residing on the streets, they should hold always with knife or gun. We also expose danger. Do you mean we should go always with that to criminal side practitioners lawyers, they are always exposed to danger. Do you mean all criminal lawyers should go to the court, to the office with gun or knife? How can you expect, man? Merely because they are exposed in public, they go with knife? He may be a picture offender. Read, you see facts, you'll see.
So that man comes to the rescue of his conscience and he is in fact stabbed on the chest. So he dies on the spot and then he before falling down, we take the man that he snaps him back on his back.
What is their avocation? These three people? They are coolies, they are not friends, they are strangers suddenly united together and kill this man.
Railway station, Bangalore City.
All right. Yes. First we will go by complaint. First narrate the facts. This is the facts. Exhibit P8. Incident occurred on what date, ma? 17. 7/11. Was working in the railway station. Complaint is ASI. PSI, ASI railway station. One minute, ma. Oh, that PW7 constable called this RFPF. Complaint on wireless. Informed that somebody has stabbed him. The deceased person has called.
ಯಾರು ರಾಮಚಂದ್ರ
PW7.
ಈಗ ಸತ್ತವನಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಡಿಸಿಷನ್ ಬಂದಿತ್ತು
ಅವಾಗ injured, now died. ಇವನು ಬದುಕಿದ್ದಾನೆ ಅಲ್ಲಮ್ಮ. PW7 still alive. Oh, you are killed only military man, more dangerous to the nation. Somebody touches military man, we will not tolerate.
So the name of the deceased?
And one more person lying there having stab injuries on the chest portion. They admitted both of them to railway hospital. Doctor declared the person who was stabbed on the chest dead. The doctor advised people to shift to the treatment inquiry. One person
Nursing.
why that man came to the railway station? Maybe on holiday. A strong military soldier has been killed. And ultimately the people have not verified from which state and what is the whereabouts of military man, nothing. He stabbed PW7 first. Then military man saw. He came to rescue of PW7. He was making effort to escape from his clutches. Then when the military man came, he just stabbed on his chest. Kumar Singh, Navitanda Singh, military personnel, examined. PW7 was on duty on railway station. One person came and informed him that some person snatched 100 rupees, one watch from him. He took PW7 to the military vehicle, parking space near the second gate, showed the accused persons. When PW7 held the accused one and two tightly, A1 took out the butter knife. A2, A3 held PW tightly, and accused was stabbed butter knife right wrist of PW7. Again, he tried to stab the butter knife PW7. PW7 raised his hand. As a result, he sustained injuries on the right palm and thumb also. He sustained injuries left portion of the stomach. He collapsed, and one Navitar Singh came in rescue of PW7. At that time, A and A2 held Navitar Singh. ಮತ್ತೆ ಅವನು ಹಿಡ್ಕೊಂಡ್ಬಿಟ್ರು. A1 stabbed with force butter knife on the right portion of the chest, got himself freed from A1 and 2 and snatched butter knife from A1, impacted the butter knife on the buttocks of A1. When A1 tried to snatch the butter knife from Naveen Singh, A1 sustained injuries on his hand. Ultimately, A1 snatched the knife, fled away from the scene. Madam, you don't know synopsis, sir. Synopsis means gist of the evidence of PW1, cross-examination, PW2, exam in chief, cross-examination. That's how you should put it, all right. Yes, ma, what is your grounds of attack?
One word started, then lost his consciousness. He has not witnessed the accused number one starting the mounting the suit. The Lordship can kindly go through his evidence.
Points. You mean to say that PW7 and 8 is not supported the case? Not supported the case or supported the case?
No, they have. PW7 has not supported the case. PW8 has supported the case, but is not smoky and his presence at the scene of other.
According to you,
Evidence is down to
PW7 not Okay. Case of the prosecution. Third aspect.
At the scene of offense is doubtful. Trustworthy witness.
Presence of PW8. The date of the offense. What is the next point?
There is absolutely no motive. The prosecution states
Motive only. Steal. Drop.
residents received and
All right.
are not known to each other. That being the case, there is no motive.
No motive. As the accused and
Residents and residents
accused and deceased are strangers. Deceased and injured. Injured are strangers.
Test identification period has not been conducted.
What for? 500 ಜನ ಇದ್ರ No TIP conducted. It is not a night. The incident at 3 p.m. Daylight. Daylight. It is not night. No TIP conducted. For what? The mob. Only 3 persons. Where is the cost of TIP? All right. What is the next point, man? Huh?
As far as accused 2 and 3 are concerned, no overt act has been acted.
No overact. No overacts. Reported. To case 2 and 3. Yes. These are the points. Yes, you now start. Read PW7, you will see. The payment of 1 minute, 1 minute. One. Yes, ma. You go by PW7 first. Start with PW7, not supported case of prosecution. See, or national, see. PW7.
As clearly stated, exhibit P1 is the statement which is exhibit P5. The statement. He has retracted from the statement. Exhibit P6. His evidence, he
1 minute.
states,
I know CW Hassan Khan. I did not know CW Lakshmi. I could not see disease.
CWP is actually the eyewitness. She has not been examined in this case. That is one of the grounds. He has not been examined. Actually, in the chart sheet, CWP is the eyewitness. Not PW8 or C.
No, you only say since I was got actually stomach injury. I could not able to see that was it. Navithan Singh. Bengaluru City and 7 PM. The office. Deputy police duty railway station. And so I came to 7 PM main and my duty on the I was in uniform. At the time, a lady and gent passenger came and informed. Yes. At that time, they came forward and put in the army vehicle, parking near area near Portico. Those army vehicle come forward. Those passengers called me with them shown to me. So I went those passengers the vehicle parking area. Not parking area, army vehicle parking area. 3 persons were sitting in the military parking area behind steps under the window towards the passenger gate. Those 3 persons, along with one lady, were discussing between them. 2 passengers with me identified. Those 2 persons, same robbed the cash and watch. Now I see those persons present in the court, accused. I apprehended 2 persons by their shirt collars and went further 2-3 steps, telling them to come to my office. The person who hold my right hand to his collar is Evan Satisha in court. The person who held my left hand, his collar is A2 Anthony in court. At the time, the person who held by me, my right hand, stabbed my knife on my stomach. At that time, there was dizzying grain. After stabbing me, both persons attempted to escape from my hands, but I did not allow them to escape. Again, the same person who stabbed me assaulted my right hand wrist, same knife. At that time, I held the person tightly. I left my grip on the other person. The same person again assaulted by the same knife on my left cheek. Thereafter, I left the assailant, went forward and became unconscious. He became unconscious. At the time when Navithan Singh, military personnel came to my rescue, attempted to apprehend those persons. In the meantime, due to the injuries, I lost blood, I fell down. Just see, a military person Dorda. Painted. Yeah, I did not know. Correct. I have not seen the assailant also which weapon. Now I see photo of this thing is the same person who came rescue of my so and so. I see the spot, I check to so and stab so and so. I knife in my foot attachment. I do think. Yes, ma, we'll continue. Continue tomorrow. As per the reading.